Hello, everybody. Hi, Ava. Right on cue. She's like, give me them pets. Give me those pets. Come on, Mama. Show me you love me. Uh-oh. I have to stand up. Your treats are over there. Just a second. This is important. I had them on the desk, and then the snitch knocked them off. Breaking in the big box of Blue Buffalo health bars. Right, Eva? She's like, I know that box. I know that smell. I know that box. Jerry sent me those. Give them here. Oh, I'll have to transfer them into one of the other containers, though, because pretty sure the cats will figure out how to get into the cardboard box. And they're not supposed to have these. They don't care, though. They want them. Just like Ava wants them. Hello, Nana Laura, sweetie. I hope you're doing well. Hello, Buzzy Pug. Hello, Linda Adams. Thank you. I was hoping to be on earlier than I actually ended up being on. But, you know, it's still earlier than usual. I'll take it. But it took me a little while in the shower to get all pretty for you guys. Hello, Joey Bag of Donuts. Hello, Lisette Panette. Oh, no. Well, I'm not going to spoiler it for you. But that's awful. I'm sorry that you're going through that. Hello, Mortimer Duke. Hello, Spider-Man. Is the court done yet? Can you hang out and play with us? And eat your pork rinds and ice cream and drink your Pepsi? Hello, Wire Mother. Thank you. Oh, thank God. I hope she does well. All right, guys. So I'm pretty sure I already know the answer to this, but put a 1 in the chat if you want to start with the body cam, or a 2 if you want to start with the courts. Hello, Dark Zoomy. Dark Zoomy. I love you. You goofball. That was not an option. Who am I kidding? That's always an option. All right. Body cams it is. I got a special treat for you guys. Do you guys remember the rapper Eminem? I mean, he was a pretty big Michigan deal for a while there. Him and his 8 Mile Road, you know. Well, I have an FTC of his wife, ex-wife. You know, the muse for many of his songs. Yeah, so we get to see her arrested twice. Yeah, she and Stan were the big deals off the pier. I mean, he literally did songs about, you know, disappearing this woman. And I guess we get to see a glimpse of why. She was a deep fake back then. All right. Well, I happened to find a couple of arrest videos, so we're going to love this.
On February 16, 2026, at approximately 6:46 p.m., Chesterfield Township police officers were dispatched to a hit-and-run accident. While speaking to the victim's mother advised officers that she located the suspect vehicle parked in a driveway down the street. Officers located the vehicle and made contact with the well-known female suspect, in which officers discovered she had a bit too much to drink.
How's it going?
Good, how are you?
Another day, huh?
I suppose.
I didn't want to move anything because I didn't know when you guys were going to be here. I was parked back here.
Okay.
And he pushed it all the way up there.
Did it hit the mailbox at all? Do you know?
It actually didn't look, it doesn't look like it did. But I mean, he was still pushing. I mean, actually, yeah, it definitely looks like it does. Mom jumped in the car and kind of took off after him because he couldn't stop me up there.
Right.
Should I move this?
Yeah, you can go ahead and move that.
After removing some debris off of the roadway, the officer assesses the damages to the victim's vehicle.
I was like, I want to make sure you see that I wasn't parked in front of the fire right there.
No,
Now
you're all right. We're not gonna write you up on that. So he pushed you all the way over here, or did you end up?
Oh, yeah.
Okay.
He was complaining about his legs because it's going through growing pains right now. So we're sitting in the living room, and we're like, all right, what's going on with your legs? And we're checking his legs out right through the window, and we were bang, and I was like, what in the world? And looked right out the window, and he was still, he or she, I don't know, was still on the car. Might have got hooked onto the hitch. I'm not really certain.
Right.
And then backed up. And then I came out. I was like, don't do it. Don't do it. And they still decided to take on up around the corner. And so.
Yeah, odds are they probably went to 94. On the off chance I went to Gratiot, just because 94 was kind of out of the way.
I was going to tell her, too, that they went towards 21.
Yeah.
Maybe he could have swooped back down the other street and came back.
And that's what I was kind of hoping for.
Really messed up. And so I don't really plan on him making it too far. It started squealing. And so I don't know. I don't know what damage she did. I don't know.
Is this from their vehicle?
Actually, you know what? It should be.
Yeah.
Yeah.
Yep, it should be.
Alrighty.
Yeah, you got a little piece.
Alrighty. So, you know what the white Range Rover is?
It's a white Range Rover. It was the newer. Are you cold? You want to go inside? Okay.
No.
It was a white Range Rover. The top was blacked out. You know, so it's a newer one. I would have to assume.
Okay.
Could have been. What's the other Rover? But I doubt it. I think it was a Range Rover.
Okay.
I don't think it was a Land Rover. It's possible, I guess. Yeah, you're good to go.
Nope.
Park. Yeah, you're good.
Okay.
Just watch out on this side.
At least people are courteous. You know, they got courtesy.
They usually don't stop for the stop sign. I'm betting that's exactly what happened with this guy.
Oh, probably.
He probably ran the stop sign because I don't see how you have that much speed.
No, exactly.
Coming around
and then
here,
you come
so
in, you
he
push
hit
a
it.
full-blown truck.
100%. 100%.
Okay, so newer whites.
I'm pretty good with cars. My dad works on cars.
Oh, gotcha.
That's a Range Rover at least.
What's up, bud?
Dad. He said, and my dad.
Yeah? Are you going to work on cars too? You like cars?
No, you're too smart. You're going to school. You all right?
And you didn't get any, the no male woman?
Nothing. As soon as I stepped out, they were already starting to take off this way and around the corner.
Gotcha.
And then she ran and grabbed her purse, jumped in the cart. She could have stopped him. I tried calling him, and her phone's here, so I have no idea.
While the officer was gathering more information regarding the investigation, the victim's mother arrived, advising the officer that she had located the suspect vehicle parked in a driveway around the corner. She also advised that there was a black car parked behind the suspect vehicle, blocking it in.
Last name? And then do you have his date of birth and phone number?
Oh no.
Where are they at?
Yep, I got out and I looked at all the cars in the neighborhood. He's right around this corner, and he's got his car in the driveway, and there's a black car that's blocking the driveway, blocking him in, and he's butted up against the garage door.
Do you know what address?
What street?
No,
What
I
address?
couldn't see the
What
address.
street?
I didn't want to get him, see.
No, that's all right.
Can you shush and let me finish? It's around the corner, I just said, right here on this corner of the street.
All right, I'm just saying, the guy's got a
Okay.
job to do.
And then left or right side of the street?
Come on, you follow me, I'll take you.
Okay. Just put your hazards on once you pass it, and then I'll be right back.
Okay.
We'll try to make contact
Can I
with
grab
him
my
real quick.
shoes?
Yeah.
You like running around?
The victim's mother escorted the officer to the suspect's house where the investigation continues. The officer observed the white Range Rover in question parked in the driveway with damage matching the hit-and-run incident. The officer also observes the Range Rover to have struck the garage door. A delivery driver delivers a package to the suspect's house just before a backup officer arrives and contact is made with the suspect.
$15 dispatch. I'll be at 5. I got the suspect vehicle sitting in the driveway here, attempting to make contact. I got a plate for the Range Rover when you're ready. David Yellow, George 992. Hello.
Hello.
Do you live here, or are you just delivering?
I have delivery. I have
Oh, delivery? Okay.
No, number.
Okay.
256.
Yep, that's here. Yep.
Okay. No problem.
No problem.
Okay.
Have a good night.
Give me 1 second. Thank you. Have a good night.
Thank you, you too.
While waiting for a backup officer to arrive, the mother of the victim stuck around to provide the officer with more information, insisting that the suspect has to be drunk.
Just let the guy do his thing. Jesus.
So I'm going to make contact with them. I don't know who it is.
He has to be drunk.
Let him do his
Based off of some things that are already observed, potentially. However, I can't force him to answer the door. So we're going to try to make
my
contact.
husband and I had, I feel like this house, a guy was driving and we followed his radiator coolant all the way to the house. I feel like this was the same house, and it was in his leak. He drove off and he left it. And this was quite a few years ago, and tried to say it wasn't him, and his whole front end was smashed. He smashed one of our other cars.
Well, they didn't
And he
know
was
when to
drunk.
stop because they already
hit the garage door.
blown through the garage door. So I'm just waiting for my partner here, in case they are combative. They're almost here.
My son thinks that he's trying to make it look like he ran into his garage door. That is the car. I saw the car.
No, I mean
That's what he's thinking, but his car's.
I came out.
from the damage on the truck and then on that vehicle, it matches up.
Yeah.
So I'm just waiting on my partner here, and then we're gonna make contact. So if you guys want to go home, we'll go knock on your door.
Awesome.
But do you guys? I'm assuming you want to press charges.
Yes,
Yeah,
absolutely.
Okay.
I'm pissed that he didn't stop. We gave him a chance to stop.
No, absolutely.
And
And,
he-
normally
he
people want to
paused.
handle this civilly, but when you're doing stuff like that, you're
Yeah,
escalating
take
it
off.
yourself.
He
Yeah.
paused. He literally paused and then he took off.
That's where I draw.
Right.
Just
was
just
like,
knock on the door, own up to it. We wouldn't even have to see a court.
No,
You know what I
absolutely.
mean? That's-
But if you guys want to get out of here, just so they don't see you guys here and whatnot,
fine.
just it's better that you guys stay
But that's fine.
anonymous type
Appreciate
of
it. I
thing.
did take
I
some
don't care about being
pictures of
anonymous.
the street. You want me to clean that up?
Yeah, if you want to clean it up, but we'll be back out there anyway.
Okay.
But yeah, we're not going to take anything since we got the vehicle right
Okay,
here. So.
awesome.
All right, we'll meet up with you guys in just a little bit.
Perfect. Thank you.
So, son is in the back seat. Son's truck's the one that got hit. Let's just step out of the road. Mom is the one driving that car. She got pissed, followed or attempted to follow, saw that car parking, and then this car changing to block the driveway. That car has identical front end damage to his rear end damage, and they just went through their own garage.
Did you run the plate?
I gave it to dispatch. They didn't say anything.
You see last name? Mathers.
Oh, it's a kid.
Yep.
I knew she lived around here, but I didn't see anything in the car. Yeah, just waters, but no, that's yeah, because part of her bumper is still sitting over there, and that's identical. So. Were you able to make an arrest on this?
Yeah. Can't run. Do they want to press charges?
Gotta determine who was driving.
Yeah. Movement in that window.
Hello.
Hello.
Hi.
Can I help you?
Yeah, so who was anyone driving earlier today that lives here?
Yeah, it was me and my niece and my kids.
Okay. And what car were you guys driving?
The Escalade, the Range Rover.
The Range Rover?
Yeah.
Okay. About what time did you guys get back home?
I know exactly what incident you're talking about. When we were coming around, you know how there's the two-way entrances, one comes this way and one comes this way?
Mhm.
There was a car that had turned into, and he was coming at us. And I had to cut deep, and I clipped the back of there's a pickup truck down there. And I was just getting them settled. I was going to go back down there and try and talk to them. But there was another car coming the wrong way up at us. And I didn't have no way but to go around him.
Okay. Because I have a witness that's saying that they witnessed it. We ended up pushing the vehicle quite a bit. And they attempted to try to get you to stop, but then you just kind of went off.
No, I have my kids in the car, and I can tell you exactly what happened. When we were coming down from Grossbeck, I turned right onto my stop. I stopped at this, and I always have my brakes on. because it's dark down there. And this guy was in a little blue car or whatever, and he came into my oncoming lane as I was pulling out. And I didn't have no choice, like, action to go around him. I didn't see the tan pickup truck, but I did feel the impact. My car felt the impact. And I said, I'm going to go back down there and take care of it. As soon as you guys all get calmed down for bed. I didn't plan on leaving it. I do have insurance. I have my tags up to plate. Like, I didn't want to leave it like that, but it was not just a one person accident. It was three, like, that little blue car involved and my car, and then...
Did the blue car hit your car, or is that just the reason why you went to the right?
Huh?
Did the blue car hit your vehicle?
I honestly, I don't know. It happened so quickly.
Okay. Okay. Have you had anything to drink tonight? Any narcotics, any drugs, any medications, anything like that?
Mm-hmm.
Well, I just had to ask because you parked your car in your garage door.
No, I pulled it up close.
No, you hit your garage door.
You hit your garage door pretty good.
Well, my kids were...
Yeah, hit your garage door and your garage door was damaged.
Yeah, my kids were, like, screaming and yelling because they thought this guy was following us, and... We honestly just came from Bugphobic Mall to get my kids some gifts.
When was the last alcoholic drink you had?
Huh?
When was the last alcoholic drink you drank?
An hour, 2 hours, maybe 3 hours ago?
Okay. Have you had anything to drink tonight? Any narcotics, any drugs, any medications, anything like that?
Mm-hmm.
Okay. Okay. Do you want to grab your insurance?
I'm gonna go see it.
Okay. Run through sobrieties. Hmm? Hmm?
On the hit and run?
Yeah. We just gotta see if anyone's, how old the kids are here. Oh, he's an adult. Yeah, we're good. Yeah. Yeah, I mean... Why don't you throw some shoes on, too, Kim? Throw some shoes on, because it's kind of wet out here. I don't want your socks to get wet.
I don't have any right here.
Okay.
It's all the kids.
Yeah, grab your insurance and your ID if you have your ID in the car. Also, you can out of the box. Get the insurance to have. He's gonna do the crash report.
Oh.
Who's all in the house?
My nephew,
How old's
my
your nephew?
son, my niece.
Are they all over 18?
No.
Okay. Oh, is there anyone over 18 in the house, though? No, there's no one over 18?
No, I have my son's grandbrother and...
The officer collected personal information from the suspect before questioning her regarding her alcohol consumption. The officer will then continue his investigation, administering SFSTs. SFSTs are standardized field sobriety tests that are designed to help officers determine whether a person is impaired or above the legal limit.
So you said they had a drink about 2-3 hours ago?
It's honestly probably longer than that. Like,
Longer than that?
we stopped for, like, at Chili's around 2. We had, like, margaritas with her mom. We brought her mom that went to Texas. And then I had her, my cousin, until the 18th for the midwinter break thing here going on. And I have 2 other kids from midwinter break with my son.
Okay. Well, real quick, we're going to do some field sobriety tests to make sure you're okay to drive. Okay? All right. So for this, we'll step back over here. So for this first one, you're just going to keep your feet together, arms down to your side, and with your eyes and your eyes only, you're going to look at the tip of my pen right here, okay? First, I have to ask, do you have any contacts, any head injuries, head traumas, anything that... A fractured what? Okay. Yeah, you're allowed to blink. It's a little windy out here. Okay. So for this next one, it's going to be the walk and turn, okay? So for this, I'll get you in a position. Don't start until I instruct you to start. But we're going to imagine, we're going to use this line right here as our line, okay? That's going to be our line of reference. So for this, yep, so go ahead and stand right there. I'm going to get you in a position. You're going to stay in position until I instruct you to do otherwise, okay? You're going to put your right foot in front of your left, heel to toe. So you can go ahead and do that. You're going to keep your arms down to your sides. And you're going to stay like that until I instruct you to begin, okay? First I'm going to demonstrate it, and then I'll have you do it, okay? You're going to take a series of 9 consecutive heel-to-toe steps, counting each step out loud. After your 9th step, you're going to take a series of small steps to turn yourself around, and then on that same imaginary line back, you're going to take 9 more heel-to-toe steps, okay? So I'm going to demonstrate, and then I'll let you begin, okay? It's going to look something like this. You're going to have your right foot in front of the other, heel-to-toe. You're going to count out loud, 1, 2, 3. I did 3, you're going to do 9. You're going to turn yourself around in a small series of steps, and then 1, 2, 3. So again, 9 heel-to-toe steps, heel to toe, counting out loud with your arms down to your side, okay? You understand the instructions as I have explained them to you?
I only seen you do 6, but I'm supposed to do 9.
Yep, you're supposed to do 9.
Turn around. Here?
Do 9.
You're supposed to do 9.
Oh, I thought I did 3. You went back.
Nope, you're supposed to do 9.
I go back.
Yep. So for this next test, it's going to be the one-legged stand, okay? I see that you have a brace on. Is there anything that's going to, you know, kind of make your balance a little offset? Okay, is that both on the left leg?
Yes.
Okay. Is your right leg okay? Do you have kind of good balance on the right leg somewhat, or no?
I try to.
Okay. Then you can use your right leg for this one. You do have the option left or right. So, since your left leg's a little bummed out, we'll use your right leg. It's going to look something like this. You're going to have your feet together, arms down by your side. You're going to raise the foot of your choosing. In this case, it'll be your left, so you can stand on your right. You're going to go ahead and raise the left foot approximately 6 inches from the ground, keeping it parallel, okay? You're going to look at that toe of your foot, and you're going to count 1001, 1002, 1003 out loud until instructed to stop, okay? Do you understand the instructions?
Yeah.
Okay. You can go ahead and begin when you're ready.
1001, 1002, 1003, 1004, 1005, 2006, 2007. Oh, that's it. We try this soon.
Yep, you can try standing on your right leg. And then raise your left one.
Yeah, no, that one's not gonna work.
Okay. We got one more for you, okay? This is a preliminary breath test, all right? So, all you're going to do is take a deep breath in and then blow out like you're blowing up a balloon, okay? Keep going, 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 keep going. All right, you can stop. Okay. All right, Kim, can you go ahead and turn around for me, please? Put your hands behind your back.
Can I let my family know what's going on?
Yep.
Okay.
No, we will. We will. You've been cool with us.
Can I do both or just one?
Why was that?
Is there anyone in the house that can move this GMC? Kim?
No.
Is there anyone in the house that can move the GMC so I can get the Range Rover out of here?
Why did my Range Rover not bring?
Because it was used in the commission of a crime, so it's going to be impounded. Operating while intoxicated and hit and run. That's why you were under arrest, okay?
Yeah, there is.
Okay, where are your shoes at? I'm going to have someone in the house grab them for you.
Okay, well, I have to give my thumb out. What's
I will.
going on?
We will. I'm just going to search it. You got anything on you?
No, I
Folks
don't.
sick, stabbing, hurt me at all?
No.
Sure. I'm going to leave all your stuff here, okay? Where are your shoes in the house so they can grab it for you?
They just ripped up something.
Nope.
Nope. My partner's going to go ahead and let them know and then grab your shoes for you.
Where's your ID as well?
In my purse.
Where's your purse at?
I found her. Okay. I need to let my nephew in.
Nope, I will. You have any jewelry on?
No.
Okay. Alright. You can go that way.
Okay. We're going to go ahead and walk back towards this truck, okay?
We'll grab your shoes and let everyone know everything else. 22 dispatch 15 have one gear for OWI and hit and run.
After administering standardized field sobriety tests with preliminary breath results of 0.079% BAC, the suspect was placed under arrest for operating while intoxicated and hit and run. In the state of Michigan, the legal blood alcohol content limit for operating a motor vehicle is 0.08% BAC. However, you can be arrested at any BAC level if you are visibly impaired while operating a vehicle or being involved in an accident. The suspect was secured in the rear of a patrol vehicle while a search of her vehicle was conducted.
All right, we'll be right back with your shoes, and then I'll let you know what's going on. But for the OWI and then the hit and run, you should be seeing a judge in the morning, okay? So because it's Monday and it's not the weekend, they'll have a judge there in the morning. You'll be able to see them, and then that's when typically they'll give you the advice on how everything's going to work from there, okay?
A small, empty Crown Royal apple bottle was located in the vehicle, along with a A&W root beer bottle, which appeared to be mixed with the Crown Royal. The suspect was then transported to the Chesterfield Township Police Department for booking. The suspect was charged with OWI and hit and run.
Floor driver and Royal Drive, female yelling, still getting further, sounds like one is possibly intoxicated. Break, anyone able to back?
What began as another late-night crash call quickly raised concern after multiple callers reported the driver appeared intoxicated. Officers responding to the scene soon discovered the driver was none other than Eminem's ex-wife, who had been arrested just 3 months earlier after another alleged drunk driving crash involving a hit and run.
Hello.
Hi.
Anybody hurt?
No.
What happened?
When I came around the corner, there was a truck coming high beam at me, and I tried to put my high beams on. It's a new car, and I couldn't see it, and I swerved out of the way of it, and I flipped the fucking car.
Okay.
And that's all I can say is, like,
Okay.
it was a fucking accident. I think this is the worst.
Okay.
And this is a new car. I don't know how to work it or the lights or anything.
Okay. Do you have
on it.
registration or insurance?
Yeah.
I need your driver's license as well. I'll talk to them.
Okay. Okay. Do you need me for anything, or?
Did you see it happen? Or?
I heard it.
Okay.
I was standing in my garage and I heard it, and.
We should be all right.
Okay.
45 dispatch can copy 2 plates.
Registration.
David Yellow George 992 DYG 992. This one is blue. Break for the other.
Here's the registration. My insurance is like on my phone.
Okay.
It's all Progressive.
Edward Lincoln Union 9355 ELU 9355. That one's black. Been drinking it all today? You're slurring really bad.
Am I what?
Have you been drinking it all today? You're
I drank
slurring really
earlier.
bad.
I did drink earlier, but not recently.
Okay. Did you have a lot earlier?
No. No.
Okay. Do you have your driver's license? Thank you.
After noticing several signs of possible intoxication, including slurred speech, the driver admitted she had consumed a few drinks earlier in the night. Before beginning standardized field sobriety tests, the officer shut off his front-facing emergency lights to reduce distractions. These tests are designed to help officers determine whether a driver may be impaired by alcohol or drugs.
I gotta make sure you're sober enough to drive, okay? Turn and face me for me. So put your feet together just like this, put your hands down at your side. I know it's a little chilly out, but we'll try to go as quick as possible, okay? Alright, don't look up at my light because it'll blind you, alright? Can you see the tip of my finger okay?
Yeah.
Okay. Keep your head completely straight. I just want you to follow the tip of my finger with your eyes and your eyes only, okay? Don't turn your head at all. Don't turn your head at all.
Yeah.
Don't turn your head at all.
I'm not trying to.
Okay. Just your eyes. You gotta do this a bunch of times, so just bear with me, okay? Okay. Some of these questions aren't meant to insult your intelligence or anything like that, okay? It's a standard question that we have to ask. Do you know your ABCs?
Yeah.
Okay. What I want you to do is keep your feet together and your hands at your side. I'm going to have you tilt your head back and close your eyes. I'm going to have you recite your ABC starting on the letter A, stopping on the letter T. You understand?
Starting on the letter what? T?
Starting on A, stopping on T.
Alright. A, B, C, D, E, F, G, H, I, J, K, L, M, N, P, Q, R, S, T.
Okay, very good. Next one is a balance test, okay? Do you have any problems with your knees, ankles, legs, hips, anything like that? Okay, which leg? Well, I tell you what, we'll skip a balance test because I don't want you to hurt your knee or anything like that, okay? Michigan law requires that you submit to a preliminary breath test on the request of a peace officer, okay? If you don't, 2 points on your license is civil infraction. Will you take the preliminary breath test for me? Okay. What I need you to do is take a really deep breath in, seal your lips around this tube, and blow really hard until I tell you to stop, okay? Just like you're blowing up a balloon, you understand? Okay, real deep breath in. Now blow. Harder, harder, harder. Perfect, thank you. Okay, do you know what legally intoxicated is in the state of Michigan?
0.08.
0.08. You're 0.20. You're almost 3 times the legal limit. Okay. For me, unfortunately, I have to place you under arrest. Okay. Go ahead and turn around for me. You put your hands behind your back. Okay, I'm not going to treat you bad or anything like that. Okay. You made a mistake tonight. It sucks, but we got to get through it.
Can I have drugs all night?
What's that? Not tonight. I gotta hold you until you're at least sober. Okay. You turn this hand this way. Let go of your fingers. There you go. Do you have anything in your pockets that's gonna stick me, poke me, anything like that? Okay. Is this just nail polish? Something?
Lip gloss.
Lip gloss. Okay. I'm just using the back of my hand on your pockets. Okay. Got anything in your back pockets?
No.
Okay. In the inside pockets? All right, I'm going to put this in your car, okay? All right. Come over this way for me. Alright.
You got it?
Yeah. Alright. Give me some light so you can see. I got you so you won't fall, alright? Do you know who your insurance carrier is on the car?
Progressive.
Progressive? Okay. I'm going to set this in your car though, okay?
After placing the suspect under arrest, officers began searching her vehicle. Let's take a look at what they discovered inside.
So odds are, at least last time, I did the blood just because she started kind of dozing off in booking. So there could be others intoxicants.
Yeah, it doesn't increase or decrease anything though.
Well, that's true, but...
Grab me your phone or keys. Just the house keys.
Phone?
So that was a little piece of information from the first arrest that we did not get at the time of the first arrest. That officer just stated that she started dozing off after the last time that she was arrested, and so he took her in and got her tested for other substances. And that's why he's doing a thorough search, is because he's expecting that this time's no different.
Looks like she's got Coors Lights over there. She says it's on her phone. But she has Progressive, I know that.
Honestly, I might have it from last time.
Okay. Oh, that's just water. Never mind, not a beer.
Yeah. These aren't open, but 6-pack of Crown.
Okay.
Nothing else in the front.
She just pled to yours a couple days ago.
Yeah, no contest.
Yep.
I mean, I don't know where it's at, but there's a cap to one of those crown shooters and an empty wrapper right there that it would have been fitting in.
Okay.
So I don't know where that is, but there's evidence that there is one open here.
Yeah. Okay.
So just something to know.
Sounds good.
While the primary officer transported the suspect for booking, additional officers remained on scene gathering information from the victims and waiting for the involved vehicles to be towed. Once at the station, officers administered a certified chemical breath test, an evidential test used to accurately measure blood alcohol concentration for court purposes. This differs from the preliminary breath test given roadside, which is used only as a screening tool to help officers determine whether further testing or an arrest is appropriate. In Michigan, the legal blood alcohol limit is 0.08%. During the roadside investigation, the suspect registered a preliminary breath test result of 0.20% BAC. At booking, the certified evidential breath test later showed a result of 0.18% BAC. The suspect was initially booked for operating while intoxicated, second offense, after previously being arrested earlier this year in connection to another alleged drunk driving incident involving a hit and run. Court records show she later entered a no-contest plea in that case, meaning she accepted the court's punishment without formally admitting guilt. Sentencing in that prior case is currently scheduled for June 17, 2026. Due to this being classified as a second offense, OWI, officers confiscated the suspect's driver's license and license plate before issuing a temporary paper permit. She was then transported to the Macomb County Jail pending arraignment before later bonding out awaiting future court proceedings. However, after the case was reviewed by detectives, investigators discovered the suspect had another prior OWI conviction dating back to 2015.
You know what's interesting about that? You remember the mom when they were sitting outside of the house in the first arrest, and she said, a long time ago, I swear it was this house that somebody hit our vehicle, and we followed the radiator leak all the way to this house. What are the chances that that prior 2015 arrest was related to that?
Because of the two prior offenses, prosecutors later enhanced the charge to operating while intoxicated third offense, a felony offense under Michigan law. Her next scheduled court hearing is set for May 28, 2026. With this being the second alleged drunk driving incident within just a few months, it raises concerns that she could be struggling with alcohol dependency. If you or someone you know is struggling with alcohol addiction, help is available. Contact the SAMHSA National Helpline for free and confidential support available 24 hours a day. Recovery is possible, and it's never too late to seek help. If you enjoyed this video, consider leaving a like and subscribing for more police body cam footage.
Wasn't that fun, you guys? I really wish she would get the help that she clearly needs. I mean, Eminem spoke of her in a lot of his songs about her addictions. So clearly this is a battle that she's been fighting for a very long time, and she's not winning it. She looks rough. Very, very rough. So I wish she would seek treatment, seek help, and get sober. Drunk in a bridge. Salty. Yeah, Purple Kiv. How you doing, love? How you doing, Purple Kiv? Yeah, she's got it. Unless it's court ordered, which, I mean, how many times are they going to let her schmuck into the back of vehicles before they order her into treatment? I think it's coming sooner than later, but it is Michigan, so it might take a couple of more incidences. Yes. And that she drives around with people under 18 in her vehicle. I have a sneaking suspicion, and I might be completely wrong on this, but she was in a mighty fine hurry to get those kids home and get them inside that night. So I'm wondering if she could have been hiding them from the police, because someone like her isn't going to think that letting those underage people drink is such a big deal. So I have a feeling that the whole reason that she ran and got them inside and out of view as soon as possible was possibly because they were under the influence of things too. Hello, Auntie M. I'm so happy you stopped in. Mwah. You beautiful lady, you. I know, but maybe if she gets sober in jail, maybe then she will, through therapy, be able to determine that she needs treatment. It's a long shot for her. I mean, there's a lot of people that I'm like, I really think they got this, you know? I'm hopeful. With her, I'm like, I think she's going to just pay cash for another vehicle and schmuck it up. I'm not opposed. All right, now we can go and do the court stuff. That's fun too. We get to see our favorite Miss Jones. She's arrested and in a different jail now. She can't stay out of trouble no matter where she goes.
I know we're not all rising. I'm not worried about that. Well, I'm not.
Ready when you are.
Okay, so the jail's up, you said?
Jail's up. Mr. Paganelli's on.
There's Mr. Paganelli. Is that Romberg sitting there?
Good morning, Your Honor.
Yes, it is.
Okay. We're gonna go with the jail first on Romberg. Been so long on Romberg, I can't remember all that we have going on. Mr. Romberg, are you related to Tony and Sue?
Yeah, that's my mom and dad.
Okay, so I remember we had this conversation a long time ago. It's been 5 or 6 years since we talked, I think. I don't know when these warrants got issued. It's been a while.
Yeah.
So anyway, if you did get bailed out somehow, you'd be, I don't know, is that address still good? That post office box in Beaver?
Yes.
Okay. Now, it's been so long since I looked at this. Mr. Paganelli, have you had a chance to look at this? I don't know what the bail amounts are on each of the cause numbers. Sorry.
Easiest way if you just look at.
Just look right there. Look at that.
There'd be 3 of them.
$10,000 cash on the, whatever that is, the 68946. And it looks like $1,100 cash on the 996-316, and $1,100 cash on the 24976. Let me look at that first one again. Did that say 10,000 or? Yeah, it did. Yeah, $10,000 cash on that first one. So, Mr. Paganelli, have you had a chance to think about these yet? He might be muted. I wonder if he's, I think you're muted, Mr. Paganelli.
So I was, Your Honor. I apologize. I've had a little bit of a chance. These are older cases, and it appears, Your Honor, that there was some pretty significant stuff that happened before they all went to warrant.
Mr. Romberg, are you actually employed at this time?
No, sir.
Okay. When's the last time you had a paycheck?
It's been about 5 years.
Okay, that's interesting. You know what we're going to do? We are going to appoint Clallam Public Defenders to represent Mr. Romberg. And Mr. Paganelli, Mr. Downing, I don't mind entering a denial today unless you think it's better for him to wait till the attorney shows up. It won't be this Monday. When would we next set him? June 1st or June 8th?
I'll note, Your Honor, that I will not be available on June 8th.
Well, technically I won't be either. I'll be in training on June 8th, but yeah, it's going to be.
My office will have coverage on June 8th.
Yeah.
If we do set something then.
Well, Mr. Romberg, we're not going to change your bail. It looks like, and I don't know if you know this or not, you have 2 warrants out of Linwood Muni, if I reading that correctly. And it looks like they're each about $5,000 a piece. So you got a heck of a lot of bail to post. And because you've been gone so long and you're unemployed, we're going to keep bail right where it is, but we're going to appoint Clallam Public Defenders to represent you. And if that attorney decides that there's some additional information the court needs to have, we could possibly get you back on, possibly earlier. But for right now, we're going to set your next court date for the 15th. Now, do you understand what you're being held on? You got a couple of probation violations. So I don't know how those are going to get resolved, but we did appoint you an attorney. Do you think you're going to be able to post that $11,000 or $12,000 cash and get out?
No, my dad's not going to do that.
Okay. So let your mom, what's that?
Oh,
I was going to say, let your mom and dad know you're going to be here for a while. Our next court date's the 15th. And they should feel free, you should feel free to contact Clallam Public Defenders in Port Angeles. And if that attorney or somebody lets me know something different, we can get you back possibly on an earlier court calendar. But we got a federal holiday that's coming up Monday, and we're switching over to a new data system on, I think it's the following Monday is the 1st. So we're it's not likely we're going to get you on another court calendar before the 15th. But if your attorney decides there's something the court needs to know, or if somebody else has some information from the prosecutor's office or whatever, we can always review this earlier. So do you understand? It looks like you're going to be in custody for a while, Mr. Romberg.
Yeah, I had a bed date for a treatment facility today, but
well,
that's not going to happen.
You can, well, no, it's not now. It's not going to happen. You're always welcome to fill out a request for a furlough if you get another bed date arranged, and we can look at that then. So anyway, you're going to be sitting tight here for a little while till we get this figured out. And Mr. Paganelli, did you want denials entered on those pending ones, or do you want to wait till the court date? That makes sense?
Your Honor, strictly speaking, I'd rather wait till he has a chance to speak with his attorney.
Me too.
Me too.
Me too. We're not trying to hold anything up, Mr. Romberg. We want to give you a chance to talk to your lawyer. So you can call Clallam Public Defenders today and let them know they've been appointed. They won't be familiar with the case yet, but at least you can get that started. So we're going to see you on the 15th at 9:30, Mr. Romberg, apparently on Zoom.
All right.
All right, sir. Thank you very much. Now, did we say Angie was
She'll be at Forks Jail.
the Forks Jail? Well, who's this person? I remember Plymail. Plymail is not in the county jail, is he?
He has bailed out.
He
I
bailed
believe, Your
out?
Honor, he was arrested, brought to the county jail, and bailed out. Per my movement roster.
So he would, in theory, is that Plymail there? Plymail, can you hear me? You need to unmute, Plymail. When did we issue that warrant? That was 2024. And what was that amount? So he actually posted $1,100. Well, Ply Mail, what's that?
Close to the bond.
Yeah. Ply Mail, if you can hear me, you need to unmute. Where did we leave off with that? What was its, I need to figure out where we left off here. State Prosecutor McKean was present in 2021. Look at that.
Hello?
Yeah, Mr. Black.
Yes, sir.
Flyman?
Flymail, yes, sir.
I know. It's been a long time since we talked.
Yes, it's been, that's what I was saying. And Your Honor, I appreciate that you allowed me to make this court appearance face to face, sir.
Well, so we had an address in Cedro Woolley. What's your current address?
Current address is my Arizona address, that I have all my mail going to, if that's what you guys are requesting for. But
yeah, I need a mailing address. Yes.
Yes, sir. It's going to be, are you ready?
Yep.
And that's Phoenix, Arizona, 85048.
85048.
Yes, sir. And it's right on the Ahwatukee border, so I don't really know how to spell Ahwatukee, but I know Phoenix is.
That's all right. That's all right. That's
yes,
all right.
sir.
So, but how come you didn't bother to call or let us know where you were for the last 5 years or so?
I don't have a good excuse to give you, Your Honor. I'm not going to lie to you or tell you anything like that. I apologize. Obviously, I'm here to take responsibility for stuff. I have no other choice to do that. So, yeah, I just apologize for my irresponsibility.
Right. Well, we can talk about that later. Are you actually working right now? Do you have a job? What's that?
Yes, I have a job.
How much money are you making a month?
I'm not exactly sure. I'd say around 6,000 to 8,000.
Okay. So if you're making 6,000 to 8,000, you don't qualify for a public defender. You understand that?
Well, real quick, Your Honor, I have a $4,000 a month payment for my apartment. I also pay my child support, which is $1,460 a month. Fuel costs and all that stuff. Like I don't want to say I'm scrimping by, but you know, like I don't have the money right now to afford that. And yeah, I think with this case, I thought it was kind of just like we were gonna work a deal out and get that figured out. But if I got a hire lawyer, I mean, I can't. But I just, you know, I don't know. I've been dealing with the defender on this one.
All right. Yeah. And also you're still cutting out a little bit. That's probably not your fault. I'm just letting you know we can't always understand. What we're going to do is we're going to send a financial declaration to that in Phoenix. And I need you to fill that out. And your next court date, Mr. Paganelli, I'm thinking of the 15th at 9:30. Does that sound all right to you?
No objection, Your Honor. If we're sending a financial affidavit out of state, I do think about 3 to 4 weeks is appropriate. I don't expect we'd get it back any sooner.
Mr. Plymail, if you could, we're going to come back on the 15th on Zoom, but I need you to fill out that financial affidavit and get it back to us so we have it in the court file before the 15th. We need to take a look at your financial situation before we make a decision on the attorney. Is your apartment really $4,000 a month?
Yes, sir.
Unbelievable. What's the job you have? What's the job you have?
I'm a commercial fisherman, sir.
Out of Phoenix?
Well, actually out of Alaska and Washington State. So that's why I was up here in Washington, that whole situation. So I'm so thankful that you're allowing me to do Zoom and all that stuff, because that's really helpful. And yeah.
Well, I wouldn't feel too nice about it yet, because I'll tell you, if we have to issue another warrant for you, it's going to be a lot more than $1,000. And you might find out the hard way. I guess you did find out the hard way. When there's a warrant in the system and you're trying to move around, it's kind of a pain, isn't it?
Absolutely, sir.
Right. So we're going to see you on the 15th at 9:30. I need you to get that financial affidavit back to me. I don't know if you're in Alaska or Washington, but we're going to send it to Arizona. You need to fill it out as soon as you get it and put it back in the mail and get it to us, okay?
Yes, sir. Thank you, Your Honor.
We'll see you on the 15th at 9:30.
Yes, sir. Thank you.
Thank you.
Ms. Jones is not cooperating.
So we can, let's see, I guess, let's see here. 30374, and this was a Forks arrest. Mr. Paganelli, I guess we're done for the day, or done for today, aren't we?
I believe so, Your Honor. I'm not on that one, although I'm not on this.
Unless you want to address that this happened in Beaver and the city of Forks is charging it.
Yeah, this is actually a city of Beaver.
You're waiting to bring her in.
Not really.
So she said, try to go in there and we'll see. Not making any promises.
Oh, she is.
Oh, there she is. There's Angie. All right. So this.
Give you a good day.
Thank you. This is the Forks ticket 30374. Angie Jones, who's right now in our jail. And we're showing Detective Fletcher with Collin County Sheriff's Office contacted me telephonically and requested assistance in an active domestic violence incident in Beaver, the Highway 101 address in Beaver. So let's take a look at this. I observed Deputy Detective Fletcher talking with Angela Jones, etc., and then talk to Vernon. We got abrasions on the right jaw and cheek, lightly bleeding, etc., allegedly inflicted by Angie. Sounds like that situation down there is very unstable. I
don't think I should live there anymore.
Yeah, I know. I'm finding probable cause for assault for, it does say DV, because I guess Vernon or somebody, it's somebody you're living with or know or something. So it's a domestic violence. Maximum punishment, 364 days in jail, $5,000 fine.
But I can't even get on the right meds. Living there, I'm treated like crap.
I know.
There's the gross ones.
Yeah, I know, Angie. So what we got to do, though, is we got to set bail. I'm going to set bail at $5,000 cash for right now. We're going to appoint Clown Public Defenders to represent you. You think you're going to be able to post, or I think that just ended, didn't it? What's the soonest we could get her on the 8th?
Put her on the first.
Let's put her on the 1st.
1077.
Yeah. I found probable cause, set bail, and then we'll do 1077 or whatever. Let Mr. Gressel know.
Okay.
Yeah, I think there's a problem in there.
I think we're good.
Is that our calendar?
It is.
She threw the tablet, Judge, went back to her cell. So
Yeah.
hang up on this end.
Well, thanks for trying.
Yes, sir.
Case 724 Northland Ranch Apartments versus Michelle Poe, Amanda Smith.
It's Michael Poe.
Michael Poe, I am so sorry.
That's okay.
Nationwide.
Who is here for the landlord?
Nationwide.
All right, I show it be an eviction petition. If I'm looking at my notes, they indicate I could not find the amount of monthly rent. I don't know if I just missed it or it wasn't listed or what, but I don't have it. Can you give it to me?
Yeah, it's $1,555. And we're seeking March through the parade of May for a total of $4,163.38 in back rent through today. Notice to vacate or notice to pay was given on March 9th. It was hand delivered and it was a 30-day notice. We're seeking back rent, court costs, and possession.
All right. Mr. Poe or Ms. Smith, what would you like to tell me?
Okay, so I'll speak and then Michael can speak. I just want to ensure that they're unable to interrupt me.
Well, I'll take care of it. I'm in charge, so I'll take care of things.
Okay, thank you so much. So First of all, we came from Sedona Springs, which is an apartment complex that's owned by the same manager as Monterey Oaks. And so they have all of these records available. And plus, I received them from Sedona Springs as well. When we lived at Sedona Springs, we never had not one German cockroach. I've never had a German cockroach infestation, but I can prove it at Sedona. And day one, moving into Monterey, there were roaches. I know hearsay is not allowed, so Michael can speak on what he heard directly from the cleaners when he was making the first delivery of our household items. But we have 2 small children, and right now they are 3 and 22 months, but they were much younger than that when we moved in July. And I constantly was I mean, they are coming out of the outlets. They were coming out of the ventilation systems. We called them the first month we moved in, and we've called them 9 times. They never took us seriously. They told us they were changing companies, but it was, this is again hearsay, I'm leaving this for Michael, but the same man to come, just in a different shirt. And they never solved the problem. They never took it serious. There was roaches crawling up the walls. One day I put my babies down with a bottle at nighttime. And then when they are asleep, I go grab their bottles and I brush their teeth. One night I went in there and there was a roach on my little tiny baby's face. And they go to private school. And so I have to do their laundry every day and I have to deliver that to their school. And I was so scared that a roach would come out of their belongings when I took them to school. I had to leave. I left with my babies because I would be a bad mother for leaving them there. We requested to be released from the apartment. They would not give us an option to move to a different unit because they said that we would infest that unit. They have told us that the building that we currently, well, Michael still currently resides in, that we are the only one with issues, and I find that highly unlikely. And if I forgot anything, I'd like for Michael to proceed to finish anything I have not said or anything that's hearsay on my part.
Okay, so just to build on that, I do have the timeline of events for our reporting of the roaches. Pretty much on the dot once a month, we would put in a ticket to say that the roaches are not resolved. They would send out treatments to our house. The guys would come in, they would spray a few corners and then take off. Some of the more advanced treatments would require us to empty out all of our cabinets in the kitchen, clean all the counters and everything, pull all of the appliances out so that they can come and do more intricate treatment, I suppose. And moving my kitchen in and out and in and out and in and out is strenuous. It's a lot of work. It's not easy to empty out your entire kitchen and put it in your bathtub so that they can come and spray and do their treatment. And then it doesn't address the issue. They're still coming out of the walls. They're still coming out of the cracks and, you know, but out of the ventilation and out of the outlets. And we found roach droppings like everywhere. And we're talking about, not to mention the building, but just our stuff in the building. We're talking hundreds, maybe thousands, maybe closer to $10,000 worth of property damage. We have a custom router that's $700 completely infested with roaches. It's ruined. We had 2 Xboxes completely infested with roaches. It's ruined. And we've asked to get out of the lease. We've asked to terminate the lease early. And the only option that we were given is that we can pay 2 months rent in order to get out of the lease. And 2 months rent is really difficult to come up with when you have children, you have bills, you have school. And now, since we abandoned the property essentially because of, you know, safety issues, we have 2 rents essentially that we're responsible for. And we're not seeking to stay in the domicile at all. We don't want any of our stuff in there. We really just wanted to get out of the lease. We wanted to be out of the facility because it's not being taken care of. And to build on what she said earlier about the pest companies, they treated the apartment probably, you know, 6 times, and it was ineffective. Multiple different types of treatments. And then they said they were going to get a new pest company, and that the new pest company would be able to take care of it because they were really on the up and up. And when the new pest company showed up, it was the exact same guy that worked for the old pest company. He just had a different shirt on.
Okay,
And he didn't do anything different.
Hang on. We're here today about failure to pay rent, and I'll address the infestation issue in a moment. But are you contesting that you, in any way contesting that you haven't been paying the rent?
We are not contesting that we have not paid the rent, but we are not paying $2,000 a month for a place that is not safe for our babies. It's not healthy for us. As soon as I moved out, 4 days later, my hair stopped falling out. I am so bug phobic. I like, my family was like, I don't know how you lasted that long.
Okay. Here's the situation.
So we're contending that we actually have vacated the property and we don't want to pay the rent for a domicile that is not taken care of by I feel like they're in breach of the lease contract because they were unable to deal with the pest issue.
Or just human rights in general.
Hang on. Okay, here's the deal. I understand you've got an issue about the roaches, and there are things you can do. There are things to file to address that. It cannot, however, be addressed in the eviction proceeding. That's a separate issue by law. I can't get into that. The issues I can get into are whether rent was paid or not. And in this situation, unfortunately, everybody agrees rent hasn't been paid. So if you need to file an action concerning the infestation, things like that, you can certainly do that. But I can't deal with that today. So I'm going to grant the eviction, issue a judgment for $4163.38. Appeal bond is going to be twice monthly rent. My order is final in 5 days. And like I say, if you need to file another action, you certainly are free to do that. But as far as the hearing today, I have to grant the eviction.
Okay. I think, did you just say that you're going to send us a way to file?
No. I can't give you legal advice. I can just say, okay, if you want to address that, you can certainly file anything you think you need to or speak
okay.
to. But all I can address is the eviction issues, and that's what's in front of me today. And so I have to grant the eviction.
Understood. Thank you.
Thank you all.
I did have one more question. I'm sorry. The bailiff in the beginning said that this was not a court of record. Is there going to be some record of? I'm assuming there's going to be some record of this judgment, correct?
There'll be a judgment. Yeah, you'll get a copy of the judgment.
Okay. Thank you so much. I appreciate you, sir.
Thank you all.
Wood County, Kansas, case entitled State of Kansas versus Paula Stevens. It's case number 2025 CR 181. Jill Gillette appears as Greenwood County Attorney. Jorge De Hoyos appears as defense counsel. The defendant, Paula Stevens, is not on the Zoom meeting. However, apparently she is available through phone, audio, through Mr. De Hoyos' office. Paula Stevens?
Yes, I'm here.
All right. This matter was set to come before the court at this time for arraignment. Mr. De Hoyos, does your client desire the charging document to be read to her?
No, that's not necessary at all, Judge.
What are your client's intentions then, Mr. De Hoyos?
So, Judge, long-term, our intention is to enter a plea to counts 1 and count 4. Count 1 is a felony, so it would be a felony plea. The parties have reached an agreement on the same, and we're prepared to do the same, although it would not probably be appropriate without Paula being available in a more appropriate fashion.
Yeah, the court's not inclined to try to do a felony plea through your phone speaker, Mr. De Hoyos. With all due deference and respect for your technology in your office, I don't find that to be a workable situation. I want to be able to view Ms. Stevens as she enters a plea, especially a felony plea. So we're going to need to reschedule this. I'll accept a plea of not guilty at this stage, at this arraignment, set this matter for what's anticipated to be a felony plea hearing on the court's next docket. Ms. Stevens.
Yes, sir.
I want to make sure you understand that this next court appearance, you're going to need to be at the Greenwood County Courthouse in Eureka and no other location. You've had a problem with technology. I don't want to take a chance you're going to have a problem with technology again. So at least the sheriff's office in Greenwood County does an excellent job of coordinating Zoom court from that location. So that's where you're going to need to be at the next setting. Understood?
Yes, yes, sir.
Mandy, let me know that if the calendar's been updated, but I think 4 o'clock on Thursday, March 19 is a date I could suggest.
Yes, Judge.
All right.
Judge,
Mr.
do you want
DeHoyos?
me to be there in person, or is it okay that I'm here by Zoom?
It's fine. It's up to you. But as
Yeah.
far as I'm concerned, you can participate from your current location.
Well, then that's fine. 4 o'clock on the 19th is not a problem.
Very well. And that would give your client, Ms. Stevens, all day to make arrangements to be at the Greenwood County Courthouse in Eureka, where she will participate from Thursday, March 19th at 4 o'clock for, again, what's anticipated to be a felony plea.
Yes, sir.
Because you eventually made some sort of appearance, even with phone audio, Ms. Stevens, I'm not going to take any further action on your bond. I'm going to maintain you under your current bond. Any previously established condition remains in effect, but with a specific requirement, you appear at the Greenwood County Courthouse in Eureka, Kansas at 4 o'clock p.m. Thursday, March 19 for further proceedings in this case. You will want to check in a few minutes earlier than that, though, Ms. Stevens, so that the sheriff's officers can get you to the proper Zoom location for court, okay?
Thank you so much. Yes, sir.
All right. Ms. Gillette, anything further we need to address from the state's perspective at this time? I didn't hear you, so since you're muted, but
Nothing further, Your Honor. Thank you.
Mr. DeHoyos, anything further at this time?
I'm grateful for your patience and acceptance, Judge. Thank you.
Very well. Then if there's nothing further, the Paula Stevens matter will be in recess at this time. This meeting may be ended for all. Paula Stevens. It's case number 2025 CR 181. Jill Gillette appears as Greenwood County Attorney. Jorge DeHoyos appears as defense counsel. However, the defendant, Paula Stevens, is not present on this meeting. Docket notes indicate that on February the 26th, it was announced to the court that there was going to be a plea in this case, in fact, a felony plea to counts 1 and 4. However, the defendant was appearing on her own Zoom and was struggling to join with video, though she had some audio connection with this. This court was uncomfortable with and made it clear that it wanted her on both audio and video when we took the felony plea. So we reset the case to today at 4 o'clock p.m., but the court ordered that the defendant be at the Greenwood County Courthouse, the same place she would be if we were doing an in-person proceeding. The court was of the belief that the technology from the courthouse has always been sound and that both video and audio capability would be available to the defendant there. We could go ahead and take the plea. The defendant is not at the courthouse, apparently, and is not on the meeting. Mr. DeHoyos, do you have an explanation?
So, Judge, I was contacted by my client this morning, and she said she was struggling to get a ride. She was trying to find a way to get to court. I made her aware that your order was explicit and clear, and I advised her that she needs to be here no matter what. Unfortunately, I have not heard from her since.
All right. Well, we've waited. It's now 12 minutes past our scheduled start time. There's been no message from the defendant to my assistant or otherwise. And the court's going to order at this time a bench warrant issue for her arrest and bond forfeiture, with Paula Stevens to be held on a no bond hold pending further proceedings in the case. And perhaps if we can get her in custody, we can then get her on Zoom and we can complete the plea that was contemplated in this case. But apparently, I can't rely on the defendant to get herself to the courthouse. All right. Let me ask counsel, has the plea agreement in this case been documented in writing?
I don't believe so.
By email, not by a plea agreement.
All right. Well, I'm confident that at least defense counsel and the prosecutor have a clear understanding as to what that plea agreement would be once the defendant is in a position to come before this court and take care of this plea. So we'll address it then. All right, Mr. DeHoyos, anything else we need to address here?
I appreciate your patience, Your Honor. Thank you.
Ms. Gillette, anything further at this time?
Nothing further from the state. Thank you, Your
Very
Honor.
well. And if there's nothing further, the Paula Stevens matter will currently be in recess This meeting may be ended for all. Have a good evening. Kansas case entitled State of Kansas versus Paula Lynn Stevens. It's case number 2025 CR 181. Richard Paw appears as defense counsel. Jill Gillette, prosecuting attorney on behalf of the state of Kansas. Paula Stevens now appears at the Greenwood County Jail Zoom location. Docket notes would indicate that the matter was came before this court on February the 26th. It was announced at that time that there was a plea agreement reached in the case, but the defendant had incomplete technology. She was unable to appear by video, so the court reset the matter for felony plea to March 19 at 4:00 p.m., ordering that the defendant must be at the Greenwood County Courthouse in Eureka to participate to address any technology issues that Paula Stevens was earlier having. However, as of 12 minutes after 4 yesterday, the defendant had not appeared at the courthouse. At that time, the court ordered bond forfeiture bench warrant with Paula Stevens to be held on a no bond hold pending further proceedings in the case. It's the court's understanding that Ms. Stevens surrendered herself to the jail in Greenwood County sometime earlier today. This court did a special setting for 4:00 today to address the case again. Mr. Paw, Mr. De Hoyos had appeared, I think, at least the last setting, if not the time before. I trust you're up to speed in this case, and what is the current status of this matter?
Your Honor, we are still set for plea today. Pursuant to plea negotiations, Ms. Stevens is going to plead no contest to count 1. That's unlawful possession of a controlled substance, that being methamphetamine. She is also going to plead to count 4, theft, a Class A non-person misdemeanor, and she is agreeing to pay reasonable restitution on that case. Judge, the parties anticipate that she should be Senate Bill 123 eligible. We believe this will be a border box case, and then Judge, if you would like me to discuss about her tardiness yesterday or failure to appear, I can do that as well.
All right, first, you say border box at level 5?
Correct.
What do you anticipate her criminal history to be, her score?
A D.
Okay.
That's what both parties are anticipating at this time, Your Honor.
All right. Please address the tardiness or the non-appearance issue.
Yes, thank you, Your Honor. Your Honor, it comes down to Paula was trying to get here and her car broke down and she couldn't get here, but she knew that there was going to be a warrant, so she got here as soon as she could today to get this matter on the way, Judge. She was trying to comply. She just had vehicle issues is the bottom line, Your Honor.
Well, in custody, she's before the court now. Thank you for your explanation. Mr. Paul will proceed further. Ms. Stevens, it's been announced that you now intend to resolve your case by entering a plea to a felony count in count 1, possession of methamphetamine, and then also there's a misdemeanor count, misdemeanor theft, a Class A misdemeanor. Is it indeed your intention to resolve your case by entering no contest pleas to these 2 counts?
Yes, sir.
I have a number of questions I need to ask you regarding the taking of such a plea. If there's anything you don't understand, I'll give you the opportunity to confer privately with your attorney, Mr. Paw, at any point. Just let the court know if you need that time to get further advice along the way, okay?
Okay.
State your full legal name for the record.
Paula Lynn Stevens.
How old are you right now?
41.
What's the highest level of education that you've attained?
12th grade.
Do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here this afternoon?
No.
Have you ever been adjudged to be mentally ill?
No.
Are you currently under the influence of alcohol or any drug?
No.
Are you currently taking any type of prescription medication?
No.
Are you supposed to be taking any mental health medication that you are not currently taking?
No.
So do you believe today your mind is clear and that you have a full understanding of what's going on here in court?
Yes, sir.
Do you understand the nature of the charge of possession of methamphetamine?
Yes.
Do you understand the nature of the charge of misdemeanor theft?
Yes, sir.
Now, when you enter a plea of no contest, you are not necessarily admitting that you committed these acts, but you're also not contesting that upon entry of this plea that you'd be convicted just the same. You understand that?
Yes.
You further understand that when you enter a plea of no contest, you give up any legal defenses that you might have had to these charges.
Yes.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, and that you could present evidence on your own behalf at your trial and subpoena your own witnesses to court?
Yes.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your own case, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes.
You understand that when you enter a plea of no contest, you give up these valuable trial rights that the court has described.
Yes.
Okay. Are you aware that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes.
Do you understand that when you enter a plea of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt?
Yes.
Do you understand that you have a right to appeal a guilty verdict if you have a trial?
Yes.
Do you further understand that you may appeal your sentence after entering a plea of no contest, but generally you may not appeal your judgment of conviction after you enter such a plea?
Yes.
Are you aware of the possible penalties that could be imposed as a result of this no contest plea that you're attempting to make?
Yes.
All right, we're going to go over those. At the level 5 drug line under the drug offense grid under the Kansas Sentencing Guidelines Act, in the most favorable criminal history category of I, you could receive as little as a 10-month prison sentence. However, in the worst criminal history category of A, you could receive up to a 42-month prison sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. As we participate today together, we do not know with certainty what your criminal history is. You better than anyone else here, Ms. Stevens, should know what your own criminal record looks like. But that will be researched by the Court Services Department, and based on the outcome of their research as of the date of your sentencing, that determines where you fall along the level 5 line, and then you'll be sentenced accordingly. Do you understand that?
Yes.
Now, there's been some suggestion here that you may fall in the D box. D box is presumptive prison. Do you understand that?
Yes.
Do you understand the concept of Senate Bill 123?
Yes.
Senate Bill 123 is a state-sponsored drug treatment program that is mandatory for some offenders, depending on the outcome of various assessments. You may or may not qualify for Senate Bill 123. If you don't, that it would be in the discretion of the court in category 5D, whether you'd go to prison or be in the community still. Do you understand that?
Yes.
You also understand that you could receive up to a $100,000 fine for this offense?
Yes.
Misdemeanor theft is punishable by up to a year in the county jail and up to a $2,500 fine. Do you understand that?
Yes.
In addition to any fines that could be imposed, do you understand that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you would do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes.
You understand that both probationary and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Okay.
All right? You understand
Yes.
that now?
Yes.
You understand the difference between consecutive sentences and concurrent sentences?
Yes.
Concurrent sentences mean they all run together. They serve at the same time. If you're serving one, you're also serving the other. That results in a shorter amount of incarceration. A consecutive sentence or box guard, back to back. That means you have to serve all of one before you start serving the other. That obviously would result in a much longer prison sentence or incarceration sentence. Do you understand that generally it's up to the court to determine whether cases or counts run consecutively or concurrently?
Yes.
Have you had an ample opportunity to discuss legal matters like that with your attorney, Richard Paul, before proceeding here today?
Yes.
You want any more time with him privately now before we go further?
No.
Are you satisfied with the services and advice given to you by his law firm's attorneys?
Yes.
Ms. Stevens, these no contest pleas that you're attempting to make, have they been based upon any threat or promises as to what this court will do in regards to your sentence, or any other type of threat or promise?
No.
Is there anything that you thought was part of this plea deal that hasn't been discussed on the record accurately already?
No.
Okay. You understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes.
So how do you plead to the charge in count 1, possession of methamphetamine?
No contest.
And how do you plead to the charge in count 4, misdemeanor theft?
No content.
Test.
No contest?
Oh, no contest. Sorry.
You're
No
not contesting
contest.
conviction, correct?
Yes.
Okay. I'll ask the state to provide a concise factual basis for each of these 2 charges.
Your Honor, on September 30th, 2025, there was a prior stop earlier in the evening that had resulted in a search warrant for stolen property and goods. Some guns were recovered and there were text messages showing they were purchased from Alexander Mays and Ms. Stevens's home. A search of the house was conducted pursuant to a search warrant at Park Street, Fall River, in the Greenwood County side of Fall River, Kansas. As they were doing the search warrant, Mr. Mays had been in the bathroom and Ms. Stevens had been in the bedroom part of the house. Pursuant to plain view, a mirror with methamphetamines was in the bathroom on the counter in open display to both residents of the household, and a bong that had contained methamphetamine and was attempted to be washed out with bleach. That being in a common area and room used by both of them, and that they both had access to the methamphetamine within the house. The count number 4 is an item of stolen property. Those are various tools and firearms that were throughout the home. They were scattered throughout the entire house. There were a Milwaukee impact drill, there were the charger, the batteries, all kinds of different items. There was an additional search warrant later that was executed for more items that were within the house that were from a second burglary out of the area, including female wigs, clothing, different things from that second search warrant.
Where would a request for restitution come from if these items were recovered?
Your Honor, it'll be a joint and several restitution with Mr. Mays. Those items that were not recovered from the burglaries. So we have been working diligently with the different attorneys involved in both cases to come up with an appropriate figure. So by sentencing, we plan to have the figure nailed down as to the exact amount. Mr. Mace is also pending sentencing. So I've been trying to work with his attorney, and then Mr. De Hoyos will have the same list of any property that was not recovered, so that we can come to an agreement on the exact amount and the restitution left.
All right. That will be sufficient. So the court will ask Paula Lynn Stevens at this time. Do you now make a plea of no contest and therefore accept conviction for count 1, possession of methamphetamine, a level 5 drug felony, and count 4, misdemeanor theft, a class A misdemeanor?
Yes.
Ms. Gillette, do you know of any legal reason why the court shouldn't accept this defendant's plea?
No, Your Honor.
Mr. Parr, are you aware of any such legal reason?
No, Your Honor.
All right, Ms. Stevens, are you aware of a legal reason or any other good reason why the court shouldn't accept your plea here this afternoon?
No, Your Honor.
The court will accept the defendant's no contest pleas and finds that those pleas are made voluntarily. She has an understanding of the nature of the charges against her and the consequences of the pleas, and a factual basis for each charge does exist. The court finds her guilty and it judges her therefore convicted of possession of methamphetamine, a level 5 drug felony in count 1, and in count 4, class A misdemeanor theft. Any other count of the information is dismissed pursuant to plea agreement. The court orders a pre-sentence report be completed to accurately determine the defendant's criminal history, and the court will set an appropriate date for sentencing. Looking at the date of May 21, Mr. Paul?
Yes, Your Honor.
Thinking about setting sentencing at 9:00 a.m.?
That would be great, Your Honor.
Sentence in the Paula Stevens case is 9:00 a.m. on Thursday, May the 21st. Obviously, the defendant must fully participate in that sentencing proceeding, which the court currently contemplates to be done by Zoom.
Yes, sir.
Expect you to fully cooperate with any assessments, Ms. Stevens, and the court will order you to do so. It's likely that you're going to be asked to do a risk needs assessment and some sort of substance abuse assessment as part of analysis to determine whether you qualify for Senate Bill 123's treatment program or not.
Okay.
All right.
Substance and what was it? Substance.
A risk needs assessment and a
risk-
substance abuse assessment, what are sometimes called drug and alcohol evaluations.
Oh, okay. Thank you.
And that would be something that probation officers will work out with you. And you
Okay.
just need to cooperate with those. All right. We got our sentencing date set for May 21st, 9:00. Ms. Gillette, is there anything further we need to address at this time?
I'm sure Mr. Pa's going to ask to address bond. So
Okay, I'll let him do that.
I'm anticipating that before I make my arguments on it.
Sure.
Okay. Mr. Pa,
Thank
the
you.
prosecutor thinks that you're going to make a motion. So
I am, Judge. Right now, she was ordered by you for a no bond hold. She did show up. She did turn herself in on that warrant. And
the next day.
Because of the reasons I stated earlier, Your Honor. I mean, I'm not going to minimize she didn't show up the same day. It's just she got there as soon as she physically could. And Judge, I would ask that we're anticipating the border box with Senate Bill 123 treatment findings. I would ask that you reinstate her bond or whatever you think is appropriate in the case.
What is the state's position on this request, Ms. Gillette?
Your Honor, we had a $10,000 bond on her with Collins Bell's bonds. Ms. Stevens, I know I am aware because her probation officers have been in contact with me. I'm aware that she has recently done a sanction over in the Wilson County Jail. I was aware that she was positive when she checked in for her sanction. Part of her bond in this case is no drugs, no drug use. That was ordered by Judge Webster, especially when we allowed her to start having contact with Mr. Mays. That was after Mr. Mays pled and we had worked out an agreement in her case, trying to resolve their cases. My recommendations are going to be that she have a new bond at $15,000 cash or professional surety, that she report to her CSO or ISO over at Wilson County, and that she continue to have her UAs. Her behavior always, and Mr. Paul knows this as well as Mr. De Hoyos, greatly affects my recommendations at sentencing. Her cooperation with this court always affects my recommendations on her sentencing date. And I know this court is very familiar with that with me too. And I believe that the court is the same, that sometimes when people don't cooperate with the court, that you take it into consideration. And I would say that her behavior between now and sentencing will show us how serious she is about her border box findings. And so I am going to recommend a $15,000 cash or professional surety bond and her to continue reporting to her ISO and have positive reviews from them, negative UAs from them, and that she cooperate with her attorney and the CSO in this case to get her PSI done appropriately.
Very well. Ms. Stevens,
Yes, sir.
your attorney has articulated well your position in this matter and laid various circumstances before this court for consideration. Do you have anything that you personally wanted to state in regards to his request?
No.
All right, Ms. Stevens, let me tell you what my concern is. You had all day yesterday to make transportation arrangements. This wasn't some early morning setting. You had all day. And in fact, it was the very last setting of the day at 4 o'clock. And you, despite having all day to provide for transportation arrangements to get to the courthouse in Eureka, you didn't do it. That's disturbing, number one. Number two, if you are having these transportation issues, it just always amazes me, Ms. Stevens, how many cars break down between people's homes and court. Because I hear this as a constant excuse for not showing up. I had car trouble. And maybe some people legitimately do. Perhaps you're even one of those people. But there does seem to be a very high incidence of car breakdowns between home and court. It's really kind of amazing. But be that as it may, if you can't get to the courthouse, how are you going to take care of pre-sentence requirements? You very well may have to come in for this risk needs assessment. You may have a separate appointment for the alcohol and drug evaluation, and you may have to come in and meet with an officer to discuss pre-sentence matters. If you can't get to court when you're supposed to, how can I count on you being able to get yourself to all of these important other sessions just between now and sentencing? And then certainly, last but not least, trust you to get to sentencing on time.
I'm working. It's just my boss went out of town for my actual person that gives me a ride, that gives me the ride to court and stuff. Christy
Who's
Cohen.
this actual person that gives you a ride?
Christy Cohen. She
Okay,
has an
and-
Airbnb in Fall River, and she had to make a emergency trip to Colorado for a friend of hers that just came out of nowhere because they ended up in the hospital. That was the emergency. So we tried to take the vehicle that we had, which was our truck, and it broke down. But
Can you give this court assurance that you will have transportation that works well enough to get yourself to all of these meetings that you will have?
yes, sir. I'm going to ask Tom McNeil. He's my neighbor. He does the public transportation for Fall River, is what I found out anyway.
Well, I certainly understand Ms. Gillette's position, and perhaps better judgment would be just to leave you where you are. The advantages would be that the court services department and community corrections would know right where you are. They could get clear access to you. You could complete your assessments. They wouldn't have to worry about appointments. And I know I could get you before the court at time of sentencing. That's the sure thing. Anything else is a risk with you, Ms. Stevens. But you did do one thing that some people don't do, and that is surrender yourself the very next day after a non-appearance, and therefore suffer incarceration as a result. You were extremely fortunate that we were able to work you in today. That's almost a fluke, given all of the calendars that had to be re-coordinated just to get you before us here this afternoon, at the end of the week and at the end of the day, but it worked out. And I also note that I trust that you still have this Fall River address.
Yes.
Okay. It's barely within Greenwood County, but it is within the county. All right, Ms. Stevens, I'm going to take a chance on you, and I'm going to reinstate your bond. I note the request for a higher bond. I'm going to decline to do that. You're back on the original Collins bail bond.
Okay.
You're not to have any drugs or alcohol as a condition of this bond. And as an additional condition, you must report to your probation officer in any other county in which you currently have those requirements. Your failure to meet reporting requirements in those counties would also be considered a violation of bond conditions in this case. Okay? So no, I'm not adding anything, but I'm going to make sure that you are regularly reporting. It would be up to those officers as to whether you're going to have random UAs or not, but I'd highly suggest to you that those better be clean.
Yes, sir.
Or perhaps that will be a factor taken into account at time of sentencing. How long have you been in custody today, Ms. Stevens? When did you report?
9 a.m.
Yeah.
9 a.m. Okay. As soon as they can get you processed out, unless you have other holds, Ms. Stevens, I'm going to order you released at this time. Hopefully you can call somebody and get a ride back to Fall River.
Yes.
Thank you.
And reinstate the original
yes.
bond.
Thank you so much.
Thank you. Judge.
Well, I kind of agree with what Ms. Gillette said. This is going to be a trial period for a couple of months. Excuse me. And I hope that you can do well between now and then. Okay. Anything else at this time, Ms. Gillette?
I don't have anything else, Your Honor.
Mr. Paw?
No, Your Honor. Thank you.
Judge,
Did
I
hear
have a
someone from the
question.
jail asking a question?
There's a Joe.
No, Your Honor, not the jail.
Okay. Okay. I'm glad there's somebody there that heard the order that you're to be released, Ms. Stevens, because I doubt seriously they would take your word for it.
It's Mandy.
Okay. Mandy?
She's to appear in person for sentencing, correct?
That's correct.
May 21st at 9 a.m.
The only place you can be, May 21st at 9, Ms. Stevens, is at the Greenwood County Courthouse in Eureka, Kansas.
And Miss Stevenson, you have a bondsman. Their responsibility is to make sure you are in court.
Yes.
If you can't find any other ride, contact your bondsman in advance, and maybe they can make arrangements to get you to the courthouse.
Okay. Thank you.
And remember that you need to contact Greenwood County Court Services as soon as you get out. Now, that will be Monday morning.
Okay, Monday morning.
Call the El Dorado number, and maybe this can be written down. Area code 316-322-4153. Tell them that you've been convicted of a felony in Greenwood County and you need to talk to someone about getting set up on the pre-sentence investigation.
I can give her the paperwork before she releases, Your Honor. Well,
Okay, great. Perhaps she can even call today, but follow that officer's direction. about what you need to do to complete your pre-sentence requirements.
Okay, thank you so much.
And the court date is May 21, 9 o'clock with you at the Greenwood County Courthouse in Eureka. All right. If there's nothing further at this time, then the Paula Lynn Stevens matter will currently be in recess, and this meeting may be ended for all at this time. Mandy?
Yes, Judge, it's recording.
Okay. All right, thank you. This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Paula Lynn Stevens. It's case number 2025 CR 181. Richard Paw appears as defense counsel. Jill Gillette as prosecuting attorney. Paula Stevens appears to be on her own Zoom. Ms. Stevens, weren't you specifically ordered to appear at the Greenwood County Courthouse in Eureka today for your sentencing?
Yes, sir. You are correct. Yes,
You're
right.
not there, but you're not there.
I understand that. My boss, she was supposed to give me a ride, but something came up with her daughter and she had an emergency. She got in a wreck, and so she had to go over by Chenoo area. And I'm truly sorry, but I am here appearing on Zoom. I'm present. I figured that at least I'm here with you, and we're taking care of this.
This matter comes before the court at this time for sentencing. It would appear from the pre-sentence report that on March 20, Ms. Stevens entered a no contest plea and was found guilty of count 1, unlawful possession of a controlled substance, methamphetamine, a level 5 drug felony, and count 4, theft, a class A non-person misdemeanor. All other counts were dismissed pursuant to plea agreement. A pre-sentence investigation was ordered, sentencing set for today. Court has received a completed pre-sentence report compiled by Micheline Thomas, pre-sentence investigator, who is present on the meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first, is there any objection to the criminal history which is stated in the report?
None from the state, Your Honor.
Is there any objection by the defense to the criminal history, Mr. Paul?
No, Your Honor.
The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to the primary count in this case is criminal history score D, and the court will proceed further accordingly. Mr. Paw, do you know of any legal reason why sentence should not be pronounced at this time?
No, Your Honor.
Ms. Gillette, are you aware of any such legal reason?
No, Your Honor.
Ms. Stevens, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing here this morning?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion for this court to address. Does the state have any such motions to pursue?
State does not, Your Honor.
Does the defense, Mr. Paw?
No, Your Honor.
Are there any victims or members of a victim's family present who desires to address the court in relation to this sentencing? Court finds no such persons present. So at this time, the court will take recommendations from counsel regarding an appropriate sentence for this defendant, beginning with Jill Gillette on behalf of the state of Kansas and the Greenwood County Attorney's Office.
Your Honor, this became a Senate Bill 123 mandatory case. We kind of figured it would be when we were talking about the plea negotiations. We had her prior PSIs and history. The state's recommendation is going to be that she have the standard 24 months as her underlying and up to 20% good time credit, that she be given up to 18 months of community corrections to complete Senate Bill 123 treatment, that she needs to follow all of the conditions set out on page enumerated 5 of the PSI, to include completing everything that is required under Senate Bill 123. I was looking to see, I don't see a drug and alcohol evaluation. The SASE has been done. But she will have to have a drug and alcohol evaluation, and she's going to have to understand that she has to follow all the rules that she is given by community corrections. She has 60 days of jail credit on this matter. And she does have 2 co-defendants, and I know that she is the girlfriend of one of her co-defendants, which is Mr. Mays. We had lifted the no contact order so they could continue residing in the same home. Under count 2, the theft of property or services, that is a misdemeanor. Would recommend a 12-month sentence concurrent to count 1, the methamphetamine, and up to 20% good time credit. Oh, sorry, it doesn't have good time because it's a jail sentence. She would have the 12 months probation to be concurrent with the 18 months community corrections. Community corrections to supervise her. There is a court cost, community corrections, and correctional supervision fees, which are 125 and 120. There
Can't hear you.
Huh?
All of a sudden, your audio went out. This as far as what this court could hear.
Can you hear me okay, Mr. Paw?
Yes.
Okay.
I can hear you now. If you'll go ahead and just repeat your last couple of sentences.
There's $193 court cost, $125 community correction fee with $120 correctional supervision fee, $45 booking and fingerprint fee, and the Senate bill reimbursement fees, which total $300. There needs to be Robinson findings on the bids application and attorney's fees. And there is a request for restitution for the items that were in the house. I believe the restitution that was attached is the guns that were in Mr. Joseph Reed's possession that he had bought off of Mr. Mays. But within the house, there was a second one that was provided in the Mays and the Reed files that were for all of the property that had been in the house that was stolen, that was damaged beyond being able to be used, and other things. That actually totaled over $10,000. So there was actually a significantly amount more of restitution. I don't know why it wasn't put into this case file, but it is in the co-defendant's case files.
So what is the state's restitution request here?
The restitution for victims, let me pull it up here. The house that was burglarized and the items that were brought over to Mays and Stevenson's house had requested $10,000. The generator was recovered, so it went down to $9,000. Let me grab that file real quick, Your Honor. Hang on one second. Her co-defendant, minus the $500 generator, had $10,405 due to victims Marlia Vaughn and Ann Wiley, which was the house that was burglarized. The other one is the $5,000 request that was sent over. Mr. Reed wanted an itemized amount of that, and when it was itemized out, it was over $8,000. So we would ask for the total of $10,405 joint and several with Mr. Mays to Marley Vaughn and Ann Wiley, and the amount of $5,000 joint and several with Mays and Reed to Mr. His last name in the back of the PSI. His name was John Jordan. That would all be joint and several with the co-defendant, her significant other, and Mr. Reed. And
So if I understand your position, Ms. Gillette, total restitution here would be $15,405?
yes.
All right.
And then there is one case over in Wilson County that is a misdemeanor. She was on probation when this case was committed. I don't know if that probation is still open. She was sentenced May 1st, 2025, and it may have ended May 1st of 2026. I am not aware if they have filed any revocation on her over there. But she was on probation when this case was committed. And I believe that is the bulk of the state's recommendations.
Very well. Mr. Paw, your recommendations regarding an appropriate sentence?
Your Honor, I would agree with everything that has been outlined by the state. Standard number, the 20% good time credit, run count 4 concurrent, the 12 months with the other. Judge, the thing I need to address is the restitution that's been asked for. Judge, by everything that I've received in the PSI, I only see one victim impact statement from Mr. John Jordan, and he requested $5,000. And then also within the, this is page 1. On page 4, when they were the cost proposed, it was listed as 5,000. So, Judge, I know there were some other listings here, but as far as I can tell by reading through the documents that I've been presented, that only Mr. Jordan filled out a victim impact statement for $5,000.
Well, this court has, on its version of the pre-sentence report, 3 additional pages of itemization over and above the sheet that just itemizes property losses signed by, I can't tell who it was signed by, but it has a $5,000 figure on it. Do you have those additional pages too, Mr. Paul?
I do, but I don't know who they're attributable to.
They're attributable to Mr. Jordan. Mr. Reed wanted an itemized list of what was stolen because he didn't want the $5,000 restitution. He thought it should be lower. And when Mr. Jordan went and had the value of the guns from the D&M gun store in Howard, these are the values that the guns ended up being. And then the extra items of coins were appraised, and that is what the figure came out to be. So they're all an addendum to his request for restitution. I can send over the court and Mr. Paul the restitution request from Ms. Vaughn and her daughter. And that restitution request, I don't know why it didn't get attached to this PSI, because normally all of them go out, but it should have been put with the PSI. I don't know if it didn't get printed or it didn't get scanned right. That it was.
All right, so I just need to know the defense position. I know the state's position on a number. Mr. Paul,
he never filled out a different impact statement. I mean, he's asked for 5,000. We're not objecting to the 5,000. I mean, and then you know, we have these additional pages. They're not signed. They're not, I don't think they're attributable to anybody, but the one that was signed by Mr. Jordan asks for $5,000.
But apparently he's not the only victim.
Well, then my answer, Judge, would be it should have been provided.
If the court wants to have a hearing for the restitution, we can do so.
It's part of sentencing, though. That's the problem. If there's some additional documentation that you can send, Ms. Gillette, that would shed some light on this, then I encourage you to do it, especially to Mr. Paw.
And I'll let the court know that the other victims actually had photos, so their victim impact statement is a lot longer than Mr. Jordan's because they had prior photos from before the burglary of items that they had taken photos of throughout the house. They had photographed the entire house, so they knew what was missing when they came back.
Well, that very well could be relevant in the future, but I think Mr. Paw needs the compilation, the numbers as to how they came up with what at this juncture. An itemized list, for example.
It's a very detailed itemized victim impact statement, but it's going to take a second to scan it because it's extremely long.
Like I say, we don't need the photos. Mr. Clausing?
Yes, Your Honor.
I have a totally separate and independent matter I need to discuss with you, perhaps at the end of this Zoom meeting. So after we recess this case, presuming that we're done by 10 o'clock, I would just like a couple of minutes to discuss that matter with you.
Sure.
Okay, thank you. Appreciate you staying on the meeting.
Your Honor, I sent it to both emails I have for you because I don't know which one you have access to where you're at. And I sent it to Mandy and Mr. Paw.
Judge, I'm printing that for you right now.
All right, thank you.
Andy, can I get a breakout room with Miss Stevens, please?
With Miss
Go ahead and
Stevens?
set that up, Mandy. Yes.
Yes,
Okay.
please.
It should be ready for you guys.
Mandy,
Yes, Judge.
can you put Ken Clausing and I in a breakout room?
Yes.
All right, counsel, I had earlier made a reference to having some business with Mr. Clausing from Community Corrections. I've now conducted that business. So the court's ready to resume, but I'm going to presuppose, Mr. Paw, that you are?
Yeah, I'm ready, Judge.
Okay, very well. We'll resume proceedings at this time in the Paula Stevens matter. Counsel and Ms. Stevens appearing as before. What is the defendant's position regarding the $15,405 restitution request made by the state?
Judge, I believe on the 5,000, that one's appropriate for Mr. Jordan. Now, on the 10,905 that has been requested by the Vaughns, by Miss Vaughn and Miss Wiley, Judge, I mean, the thing about it is when you look at this impact statement, it was filed under Mr. Mays's case. The victim impact statement only references Mr. Mays. I know there is a itemized agreement, but Judge, I would still object to the $10,905.
All right. So, Ms. Gillette, where does this leave us?
Your Honor, these items were recovered throughout. Some of the items were recovered throughout the home that Mr. Mays and Ms. Stevens resided in together. A lot of it had been destroyed. When the burglaries happened, the items had been strewn throughout a field and left, and they got rained on. but many of the items had been hauled into the house to try to sell, clean up, or do whatever they could with them. This is something that Ms. Stevens, that's why she is charged with the theft of having stolen property, knowing it to have been stolen, because items were all over the house. So Miss Stevens would have known that there was stolen property in her house. And that's one of the reasons for the theft charge. And therefore, she would have had knowledge and possession of the items mostly destroyed throughout the situation that was going on with Mr. Mays burglarizing houses because they resided in this house together.
Was there a plea agreement in this case that the defendant would be responsible for more restitution than contemplated by the misdemeanor theft statute?
I don't believe there was anything in that plea agreement, Judge. It was just going to be where she fell in the box in the sentencing grid, and court reasonable costs, court costs and that. The rest
I have notes that say we agreed to restitution, and I believe it was announced at plea, but it was an oral plea.
But was the amount announced at plea?
I don't think the amount was announced at plea.
I think that is correct, Your Honor.
Well, it's hard to see a meeting of the minds on an agreement when the figure wasn't even mentioned. This should have been settled at the time of the plea. Now we have a considerable dispute of over $10,000 difference in restitution numbers. And I presume that this information would have been available to both sides as part of the discovery materials that existed in the case. So it's frustrating that we get to sentencing and all of a sudden I find out that we have a restitution number issue in this case. But apparently there was just a general agreement that Ms. Stevens would pay restitution to the victims. Is that right, Mr. Paw?
I believe so, but there was no amount given. I mean, it was everything I think was reasonable cost is usually the terms we use.
So, Ms. Gillette, what do you propose here?
If the court wants to take up a restitution hearing, we can bring in the victims to testify about all of the restitution. And this one, they had anticipated receiving restitution, so they didn't appear today. But if we need to have a hearing on the restitution, I actually send subpoenas for them to have them come in.
Well, if you and defense counsel can't reach an agreement on restitution, then a hearing is going to be necessary. All right, I'm going to address my assistant. Mandy, we're talking about an in-person proceeding in Greenwood County. What date can you propose?
Judge.
And I would think this is going to take us a couple of hours, so.
Okay, so we're gonna have to move this to July 16th then. We don't have time on the June 25th date to do this.
Okay, so what would the time frame be for July 16?
Okay, we could go in the afternoon. Maybe 1:15 or 3, 2. The whole afternoon is open.
Okay. Mr. Paw, would you check your calendar for that date?
I have, Your Honor. I would like to have it start at 1:30 in the afternoon.
All right. We can accommodate that.
I was gonna say, I have a case down for 1 o'clock or 1:15 on that day already with Judge Ricky.
We had a
Mandy?
David Hill there, but I took it off for some reason. I can look and see.
Okay.
Yeah, I don't want to set up a conflict here.
Yeah, he took a plea. That was set for pretrial. He's set for sentencing the 25th, actually.
Okay, great.
Of June. Okay. All right. Court will set a hearing for sentencing and restitution, 1:30 p.m., July 16, 2026. The defendant is ordered to be personally present at the Greenwood County Courthouse in Eureka, Kansas, and cannot appear by Zoom. Ms. Stevens, do you understand that order?
Yes, sir.
Okay, we didn't appear to fully understand it last time, and I'm upset that you are not where you were ordered to be.
I understand that. Yes.
But only because that we've had this glitch regarding restitution. Apparently you're going to get another opportunity to appear at the courthouse like you were ordered to do. July
Yes, sir.
16th, you need to be there early to get checked in, okay?
Okay.
Perhaps meet with Mr. Paw. So you should be in that building by no later than 1:15 p.m.
1:15.
The hearing will start at 1:30, July 16, in person, Greenwood County Courthouse, Eureka, Kansas. I'm going to mark off 2 hours for the hearing and sentencing. And again, obviously, it's contemplated sentencing, and for all other purposes will be deferred to that date. But I have one other issue I want to address while I have everyone here, and that was the computation of jail time credit. Generally speaking, jail time credit doesn't accrue on the first day, but only when you've served an entire day. In other words, one day is credited the next day. For example, in this case, first, she apparently went into custody on September 30. It is on October 1st that the first day is credited. The computation would appear to be 1 day off in the view of the court. It would be 31 days of October, 27 days of November for 58 on the front end. And then generally, depending on the number of hours that the person spends in custody, the court wouldn't give jail time credit for a bond out on the same day. Now, I don't know exactly what happened on March the 20th, that another day is being offered here for jail time credit, but she apparently went in and went out of custody the same day. Does either attorney remember the circumstances as to how that shows up on the records of this case?
No, Your Honor, I don't remember.
Well, generally the court would view this that since it's just perhaps a small partial of a day, that she wouldn't be entitled to a full day of jail time credit.
Normally, they are not marked as a day.
So I think the proper jail time credit computation is total of 58 rather than 60. And if there's a dispute on that, let's address that now. Ms. Gillette, do you dispute the court's jail time credit computation?
I do not.
Does the defense, Mr. Paul?
No, Your Honor.
All right, very well. Then I would just ask Ms. Thomas to correct on the new face sheet, which indicates 58 days of jail time credit, 58 on the first line and 0 on the second.
Yes, sir. I'll
Thank
get
you.
that.
Thank you, Ms. Thomas. I don't know if there's any other alterations necessary on the pre-sentence report at this point. I do note that there's a dispute over restitution, but I don't necessarily expect that number to be changed later in the pre-sentence report, because that is a matter of controversy. And I see where the $5,000 number came from. Okay, we've got the entire matter reset for July 16, 1:30 p.m., Greenwood County Courthouse in Eureka. The defendant is ordered to be personally present at that time. She's nodding her head, so I think Ms. Stevens understands.
Yes, I understand.
Ms. Gillette, anything further we need to address in this case right now?
Nope, none from the state.
Mr. Paul, anything further from you, sir?
No, Your Honor. Thank you.
Thank you all for the attendance this morning of the professionals involved in this case. I regret we couldn't get things done in this case today, but we'll address things further on July the 16th. At this time, this matter will be in recess.
I'm not gonna lie. I couldn't tell you a lick of what just went on. We've all been in chat talking about Jill stealing ducks and allegedly, of course. I put the link for the Jill stealing ducks thing in Discord. So you'll see a hashtag and then all video links. That one is in Insomniac chat for those who don't have the all other video links thread activated. But it's in both places essentially. So Oh, Joey Bag of Donuts, absolutely zero. Yeah, she's not gonna show up. All right, give me a moment here. Remove this. Okay, now I'm going to share my screen. All right. We are going to go to the link tree. This is link tree. Sure. Okay, so I'm showing this because Holly was having Discord or not seeing Discord in the link tree. But it's got the address, Buy Me a Coffee, PayPal, Amazon, and then Discord. So it's there. I have zero idea why it's not showing up for you, sweetie. And then it's got the YouTube channel and my email, which I'm terrible about checking. I'm the worst email person in the world. I will see it eventually, and if you tell me you emailed me something, I'll go check it. But I am horrible. I'm horrible about it. I don't look for email. So I wish I had an answer for you, sweetie. I don't know why your Chrome and your Android aren't showing it. But I do want to say thank you to everybody for coming and hanging out with me. I hope you enjoyed the lot tonight. I know I loved the Eminem's ex-wife thing. That was kind of special. And then going to Clallam County, I always love that. Judge Hannafy is, as you all know, he's in my tops of favorite judges. Yes, Jerry, you were so late, but that's okay. That's okay, Jerry. I understand the pain. I had to, I think it was during the FTC case at the beginning of it. I think it was. I don't know. I don't even know which case was on. All I know is my leg started shooting pain at the same time that I was getting tased in my butt from the spine injury. And I'm like, oh, goody. Now, not only is my spine cluster pinched off, but also my sciatic nerve. Yay. So I went to the kitchen and I lied down on the floor and I put my ankle on my propped up knee and then I just pushed it like down to stretch that tendon. That's supposed to be what helps, supposedly, according to this chiropractor on YouTube. Oh, thank you. I put it in Discord, so it's in both Insomniac chat as a thread link, and it's in the all other video links thread. So 7-minute mark. Oh, thank you so much. Oh yeah. Well, and I can't take ibuprofen at all now because if I do, horrible things happen. Horrible. I put the link in Insomniac chat, Mortimer Duke. I will personally link you. There you go. I DM'd you. I slid into Mortimer's DMs again. Holly Naomi, you ain't wrong. When you said YouTube be YouTubing, that was spot on. And I'm so glad that it's at least showing for you now. I was ready to solve the case, but I couldn't find what was wrong. Yeah. Creators from all different kinds of backgrounds have been complaining about it. Oh, absolutely. Well, and I've seen some pretty wild things that, like, when I notice I'm having issues with certain aspects of YouTube. For instance, For instance, YouTube was doing this thing where the video would freeze, but the audio would continue. And it was driving me crazy. It was driving me absolutely bonkers. And so I was watching another streamer that I like. His name is Salty Cracker. And so I was watching him, and all of a sudden I noticed a video he was playing. The video froze and the audio continued. And he just, he kept talking. He didn't realize that it had happened in the moment, So I was like, I'm not alone. It's such a validating thing when you see someone else having the same problems that you're having. Sorry, a goofball just texted me twice. Oh, yeah. Yeah. I've I get censored a lot. A lot over the silliest things. Like saying something as simple as "you beat me to it." It's got that word in it. That one word. It let it go through tonight, but I can't tell you how many times it has censored me from saying that. And it's like I filed complaints with both StreamYard and YouTube. Yeah. Oh, I've had people ask, in chat, like, they're like, why can't I see so-and-so's comments that you're putting up on the screen? And it's like, well, okay, change it from top comments to live or whatever the magic handshake is to get it to work. But yeah, and now they're making it just almost impossible to be a content creator. It's hard now. It really is. It's a lot harder than it was when I first started doing this. But it's okay. Silence. All right, guys. I'm going to go silence myself. Yeah. No, I know. Oh, I've trust me, I've been accused of being a bigot and being, all kinds of things. You won't let me say you're inhibiting my free speech. And it's like, I ain't doing anything. I am very pro free speech. Like I've had people yelling at me over someone's comments. Sometimes. And I'm like, they're free to say what they want to say. I'm not censoring people unless it's super racist or something like that. Like I'm not going to allow people to be hateful in my comments, but jokes are jokes. And everybody has a different sense of humor. Some people, it's real dark. I'm on that end of the spectrum. Some people can't handle a joke. We have them here too. And they're fine. As long as everybody just blends into this beautiful melting pot that we got going on here, it makes a wonderful soup. All right, guys. Jerry, go back to the beginning and watch, or wait till the morning when the I don't know what to call it, the raw video, but that sounds so horrible. The body cam video without comments, without chat, without cat tree, that one is going to post in the morning. Please like it, hype it, comment on it, share it, do whatever you got to do. Super appreciate you all. And I love every one of you. You guys are amazing and you make me laugh so much. So much. And I appreciate every one of you. Now go watch Jill steal a duck. Be safe, be well, sleep sweet, and much love.